So welcome everybody to today's very important class for everybody, Legal and Financial Basics. And as always, I'm very, very pleased to introduce Kimberly McGhee. Kimberly has been in the San Diego area for a number of years. I'm not sure how long, but she's certainly well known here in San Diego County, but beyond that as well, too. She is a certified elder law attorney, one of only two here in the county. So she's really a specialist in this whole area of elder law. And she's also a certified specialist in estate planning and trust and probate law. And these are all the areas that are applicable to us as we are aging in terms of ensuring that assets are protected and or that we have assets to help pay for our care, in addition to a myriad of other legal and financial issues that often come to us with older age. Her practice does focus on elder and estate law with long-term care planning, also Medi-Cal planning, VA benefits, conservatorships, and probate and trust litigation. So she does a lot of different things. And I'm also just going to say that she is a renowned speaker here in San Diego County and through the state, and I'm quite sure nationwide. And she's a terrific and very dedicated and passionate advocate for at the legislative level for concerns regarding dementia and regarding elder loss. So we've got a champion here in Ms. McGhee with regards to the things that concern all of us as we are aging. So I'm going to turn it over to her and we're going to just dive into things, and she is going to tell us all sorts of interesting things. I'm going to go off camera and audio while Kim is speaking. I'll come back on at a later point. Here you go, Kim.
Okay, good afternoon, everybody. Jean, thank you so much for that. Welcome. I'm hoping you can all hear me. If somebody can hear me, someone put something in the chat. I don't see anything. Can you hear me out there? Okay, good. Thank you. I want to thank everybody. Jean, that was wonderful introduction. I am as Jean said, I'm a certified elder law attorney here in San Diego. I was actually born and raised in San Diego. I am a native. Um, this I have been doing this presentation, I want to say since 2014. So I want everybody to bear with me today because we have slightly altered it. So if I go a little off script or it appears that I'm a little bit bumbling, that it's because I'm trying to learn new slides. So thank you for your patience today. And again, I may go too fast, I may go too slow, but I want to make sure there is time for questions. So there are certain things that the slides are going to be available. So if there's any questions, you can always go back to them. And I can see Wendy wants to know my name. I am Kimberly McGhee. Okay, let's see if I can make the slides move. There we go. There I am. How do I get off there? Okay. So we really begin this presentation with walking through the basics of planning, right? We're entering a world, either you're in the world, you're dealing with the beginnings of the world, you're smack dab in the middle of it. This is a very difficult time of everyone's life. It's difficult for the person who's been diagnosed. It's difficult for the family. It is going to always be hard. There's no easy way to say this, but the best way you can handle these issues is with advanced planning. So my current profession, right? An elder law attorney, nobody really knows what that means, but it's 12 subjects. And there are some that focus on planning. There are some that focus on crisis, dealing with the crisis, and then others that deal with the end results. My practice and the firm I'm with, we focus on when things go bad, right? Or when the plan doesn't work. I did estate planning for a very, very long time. And as a result, I've learned that the people in the middle whose plans were either done poorly or do not have plans really are where they need me. That's where my advocacy focuses on now. My firm, we do a lot of this type of work. So we always like to start everybody with don't come see us. You don't want to see us. You want to have a plan in place such that your wishes, your loved one's wishes, or that you can care for your loved one are enabled and allowable. And the best way to do it is is advanced care planning, right? We've got, what is it? It's the what ifs. It's making decisions about the care you want to receive if you become unable to speak for yourself. I make the joke that I'm obviously a control freak if you once you get to know me. I have to be in control of everything. Um, and this a plan, a lot of people think of a plan as I'm giving up control. I'm putting other people in place. But you're not. What you're doing is you are creating a plan that keeps you in control. Your wishes, your decisions, people that you decide. So it is very important that you put this in place, or your loved one puts this in place, or you force your loved one to put in place. And I can tell you, I hear all the time, I don't want to do a trust. I don't want to do a power of attorney because I don't want to give somebody else power. That's not what it is. You're keeping your power, you're retaining your power. And so trying to explain that to somebody who is slightly obstinate about it, it's important that, do you want to stay in control? Then we better put it in writing, how to stay in control. And it does require discussing these things. We all want to put our heads in the sand. Nobody wants to talk about this. I always make the joke, it might not be, I guess we're coming up to Easter. It's not Easter dinner conversation, but it has to be had. It's a conversation that you need to have with your decision makers, with the remainder of your family, and with competent legal counsel, financial planners as well. You're going to hear this a lot from me if you ever get to know me, that, if you penny pinch or try to save a buck at the beginning, you are going to spend so much money at the end. And a really well thought out plan and a really well drafted plan will never cross my desk. And that's what I want. I don't want to have to drive up to Ventura and spring somebody from a facility because they put the wrong person in place, or they didn't create a plan that was strong enough to be upheld, right? I want to make sure that your wishes are upheld, which is why one of the main reasons we need to have this conversation. It's not moving. Give me a second. Oh, see, there's a delay. I apologize. Okay, the value. I really kind of walked through some of that, but the most important part is when you have no crisis in place, you have all the options. They're available. Your box is really big. When there is a crisis, number one, your frontal cortex is not firing correctly. So you're going to make decisions based on fear and other types of emotions that are not what you want. So if you plan ahead, you reduce making critical decisions during the crisis. They're also going to reflect your personal value and preferences. If you get hit by the bus and have a traumatic brain injury and nobody knows what you want, they're going to do what they want or what they think you want. And 99% of the time, people are wrong with what you think. My favorite story is about a husband and wife who they went into a hospital to help to just be there with a friend who was really ill. And after 41 years of marriage is when they learned that they have the exact opposite end of life choices. They both assumed the other one wanted what they wanted, which is either pull the plug or extraordinary measures. And 41 years of marriage, they did not know that. So if you think your loved ones know, you're probably wrong. The value of planning is we can preserve eligibility for public benefits. The most expensive time of your life, people think it's when the kids are in college. It's not. It is your long-term care. And that is if you get any type of major neurocognitive disorder, dementia diagnosis is going to be the most expensive time of your life. And so that is why we want to kind of look at how to plan for this, but we also want to avoid the aftermath of when you pass, right? So we want to avoid probate proceedings, and also we want to avoid any recovery type proceedings as well. So estate planning. Estate planning, I'm telling you, a lot of people are like, oh, it's for rich people. It actually, the more money you have, the less estate planning you need because they generally have all sorts of other financial and business planning such that they don't have estates. So I tell people estate planning is for most of everyone else. If the 1% don't need it, everyone else needs it. But estate planning is just administration, protection, and distribution of assets. So during your life, when you're alive and well, when you become incapacitated, and when you die. And that's what it covers. Benefits planning, we're going to talk about that. We're going to determine the eligibility for what you are able, how to prevent and protect for it. And then also there's special needs planning. A lot of my clients over the years, they have adult disabled children. What's the plan? Right? You've lived with mom and, your child's lived with you for 58 years. You're getting ill. What's the plan? They've never had any other caregivers. What's the plan? So in order to really start this process, we really need to understand what capacity is. And capacity truly is a very difficult word in our legal system because it doesn't match our medical system. And that is something that, Jean mentioned. I do a lot of legislative work, educating legislators on the difference of what legal capacity is and what medical capacity is a very difficult thing, because what you're legally able to do may not be what you're medically able to do, which is a very interesting dynamic that we deal with as lawyers. But it's the capacity or fitness to perform an action or enter into a legal agreement. So what does that mean? Probate Code 810, everyone is presumed to have capacity. We all start from the same spot. Then people are like, they call up, well, my mom has dementia. I need to take over. I can't tell you how many times I hear that. Please don't ever do that. Don't call a lawyer's office and say, my mom has dementia. I need to take over. Because that's not true. Probate Code 811D says a diagnosis alone is insufficient to deem you to lack capacity. What does deem you to lack capacity is that diagnosis impacting your ability to understand the nature and consequences of your decisions. And it's a specific decision. It's not a fixed issue, right? I can have capacity for one thing and not have capacity for another thing. It is very confusing when we talk about it. And so people like to say, oh, there's a diagnosis. No, I may not be able to do one thing, but I can do something else. And so, okay, I make the joke to lawyers and that I might be the only lawyer in California that likes doing conservatorships. It's not that I like doing conservatorships. They are the nuclear option. It's that I believe that they are a very useful tool to protect people, and they are protective proceedings, and they can be utilized appropriately to ensure that either your your unwell crafted, your not well crafted estate plan is still implemented, or they're used to make sure that you are protected from the bad guy. And it's a court proceeding. And thanks to Britney Spears, I can't believe how often I thank Britney Spears, but thanks to Britney Spears, most people know what it is. But it is where an individual, so a family member or professional, is going to be appointed to be your decision maker or your loved one's decision maker. Other states call them guardianships, so it gets very confusing. But we don't want them. They're nuclear. I call them, we try to avoid them at all costs, because as opposed to an estate plan, you stay in charge. The person who wrote the document stays in charge. You need court orders to usurp their decision making. A conservatorship, you step into the shoes and you do become the decision maker. So what documents do we need to avoid this nuclear option? Number one, a will or a pour over will. And a will is just a document that applies when you're dead, right? People will call the office and say, I'm the executor of my mom's estate. And I'll say, oh, I'm so sorry for your loss. And they'll be like, what do you mean? My mom's still alive. Well, then you can't be the executor of anything, because a will does not become effective until somebody is dead. It also requires to be admitted to probate if it's trying to collect assets over a certain amount. A trust, on the other hand, becomes effective upon signing, meaning that a trust, and I think we go through the details of these, but that if you own real property or assets over $200,000 approximately, that number goes up with inflation. So if you own a certain amount of assets, you're going to want a trust. But you definitely, I tell everybody, at a minimum, you need powers of attorney. There are two kinds. There's a durable power of attorney for asset management, and then there's also the power of attorney for healthcare, which in California we call the Advanced Healthcare Directive. So that's the Advanced Healthcare Directive usually has this power of attorney nominated in it. And it's used to be called the living will. Some people still call it the healthcare proxy. When in doubt, blame the lawyer. It all means the same thing. You're going to always want to have some sort of waiver, some HIPAA waiver, right? How many times have you now heard, I can't give you that information? Prior to COVID, people got away with a lot of things. HIPAA's been around since about 2003, but it wasn't until COVID that people realized we were just giving information willy-nilly to family members or people claiming to be family members. So now you run into, does this person have access? Do they have the right to information? You can't call the doctor and ask me. So ask for my medical information, I'd have to sign a HIPAA waiver. So that's kind of why you need it. DNRs and Pulse, I have met a 55-year-old woman who came in my office, her and her husband came in my office, and they both had pulses. And I thought, oh my gosh, I'm so sorry. What have you been diagnosed with? And they like looked at me like I had two heads. And I said, what do you, and they're like, what do you mean? And I said, a pulse is a physician's order for life-sustaining treatment. It is a physician's order, meaning that what it says goes. And I said, it's only intended for when you are 1 year from death, or you have, or you're of a certain age that there is certain types of medical procedures you no longer wish to have. And such like chest compressions at 96 years old. You're at that point, the likelihood of your ribs repairing themselves is unlikely. So you only want electromagnetic, those kind of things, or electric ones. But the pulsed should only be considered for those times of your life. I've seen some doctors push them, and I'm not sure why. But the DNR and the pulse, you don't want an order unless you're certain that you do not want to. Because if something happens to you and the paramedics come and they see a pulse, they will watch you die. I don't care if your healthcare power of attorney says, no, 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 please do treatment. If there's an order saying that they don't want treatment, that's it. Okay. So I fear, because again, I don't know these documents or these slides as well. I just want to make sure. Okay. So we're going to talk in a little bit more detail about what these documents are. So we want to either maintain current documents or we want to or create new ones. So we want to review the existing estate plan fairly regularly. And I'm going to go back to what a basic plan is going to have. So your revocable living trust, that 90% of people are going to benefit from this. People are like, I don't have enough money for a trust. If you own a real property, if you own a house, you should have a trust. It is almost irresponsible to not have a trust at this point for multiple reasons. But people think, well, what is a trust? A trust is just a contract that you have with yourself, right? I, Kim McGhee, decide that I want to own assets in the name of Kim McGhee, comma, trustee. So when I am alive and well, I'm in charge of my assets. And then I say, well, if I become incapacitated, I have a traumatic brain injury, or I get diagnosed with dementia such that I'm no longer able to manage my affairs, then I have decided that I want this, private fiduciary, because my kids are too little, to be my trustee. And then if I die, I want the same private fiduciary to manage the assets for my kids or distribute it outright because they're old enough. That is a trust. It's nothing complicated. It appears complicated, but it truly is two important things. I'm in charge of my life when I can be. If for some reason I can't be, who is in charge of my life? And they're going to manage it for me while I'm alive. But when I die, this is where I want it to go. People seem to skip that middle part. They go, well, it's my asset. And then when I die, it goes here. That's not what happens. This is my asset for my benefit and I manage it. Then I can't manage my asset. Who's going to manage it for me while I'm alive? And then who's going to manage it when I die? And so when we're talking about people with major neurocognitive disorders, this is when we jump into it. This is when that successor trustee needs to take over, because the manager of a trust is called a trustee. The manager of a will is called an executor. And the manager of a power of attorney is called the agent or power of attorney, or attorney, in fact. Again, when in doubt, blame the lawyer. So that's what you want. The power of attorney for asset management and the power of attorney for healthcare, or the Advanced Healthcare Directive. Those are documents that every single person watching should have right now. And because I'm assuming every single person is over the age of 18. The joke I make is you should have started your estate plan when you turned 18. What I do, a lot of my friends' kids are turning 18 right now. And so for their birthdays, they get powers of attorney. And everybody's like, Mrs. McGhee, I don't own anything. And I'm like, okay, well, you have a phone, right? And they're like, well, yeah. And I'm like, so if you get in a car accident, who's gonna pay your bill? Who's going to access it and make sure that everything's okay? If you don't, you're gonna lose your iCloud, your TikTok, all the things. They freak out, they say, I'll sign anything, right? But it's also, and I'm like, well, who's going to talk to your doctor if you get in a car accident? And they're like, well, my mom. And I'll be like, no, you can't. Remember HIPAA? We just talked about this. They don't have the authority to talk to anybody. So we want to make sure that you have this in place. And it actually worked out amazingly. One of my friend's kids, he went away to college. He had a baseball scholarship out in Oklahoma, I think it was, and he got injured. And she was shocked about how easy it was to manage his health care from California while he's 18 years old in Oklahoma. And it doesn't happen often, right? But it does happen. So that's what everybody should have. So that's like the minimum. If you take anything away from the basic documents, get yourselves powers of attorney right now. And the slides are not moving. Bear with me. Hmm. Okay. I went too far now because I pushed the button too many times. So bear with me, everybody. Thank you. Okay, I guess before I stop there, I do want to check to see if there was any questions just on that was specifically based on the documents. We're going to get through the detail questions, but um, okay, so somebody did ask if there are assets not greater than 200,000, then a trust is not needed. I will say, without knowing all the details of your estate, that in general, the answer is going to be no. But it's an entirety of the assets. So it's not just one bank account that has $130,000 and another bank account that has 70,000 and another one that has 20,000 because we also have a car. We also may have other things. So in general, you're going to be okay. But what happens? What happens when you die? The reason a trust works so well is it decides what's going to happen when you die, right? Who can access it? A trust is needed when you need access, you need a signature to transfer an asset. Like, for example, how do you sell a house? You sign a deed. What can't you do when you're dead? Sign a deed. How do you close a bank account? You sign a statement. What can't you do when you're dead? You can't sign your name. So that's what the trust will do. So it really is going to depend on those assets. Are they payable on death? Can you access them afterwards? And okay, who should you pick for these ideas? Okay. When you go and meet with an estate planning attorney, there are some that are better than others. And Alzheimer San Diego has a nice list of great ones. I've got referrals as well. Um, it's important. You are not to pick the firstborn son or the caregiving child as a just standard because it's the person who can do the job. You are interviewing, when you're deciding who's going to do this, you're interviewing this person for a job. Would I, and I don't mean this as a negative because, a lot of parents, they give loans to their children, they do things to help them out. But if they've had to loan money to their child, should they be the one in charge of their assets in the most expensive time of their life? It's not a judgment. It's just are they a good money manager? Some people are better than others. Some people are too good, almost they're too frugal too. I mean, those are the things. So you need to be, who would I hire for this job? Think about it. I only have two sons. I make the joke. My daughters-in-law will be picking out my nursing home. So I always think about because I've watched it. I have sat in the room when I have heard twice, not just once, but twice, two daughters-in-law, we call them outlaws, not in-laws. So two outlaw daughters-in-law, both in different ways said, why are we spending so much money on mom's care? So and so is going to start college soon. Or, we really wanted that new house because you're spending their ultimate inheritance. That's a real thing. And so you need to be mindful of who's in control, who's in their ear when making these decisions. So that's how you would pick, you know. I ultimately originally had one of my brothers as my healthcare power of attorney because obviously he's the perfect one. He's a doctor. And then my father had a health event in 2014, which actually spurred into why I do what I do. And I had to remove him the next day. I went and I called from the hospital to my office and said, please update my power of attorney and remove my brother. And not because I don't love him, because he's a great guy, but doctors do what other doctors say. And I was shocked and I needed an advocate. So right then and there, I had a new evaluation and appreciation for what happens. So you want to pick somebody who will. And unfortunately, we are in the business of medicine, not the practice of medicine now. And so it's important to find an advocate who you want, who you should give the advanced healthcare directive to. That is a really good question because it's whoever that will keep it, right? Every time my dad had a health event, which is every 2 weeks, we would bring it down to the hospital like it was the first time they've ever seen it. I know that there are some VA hospitals that will keep them on file, which is phenomenal. So every doctor should have it. You know, these are the things, but whether they'll keep it and have it accessible, I can't tell you. Um, how often, so we talked about keeping these updated, right? Okay, let me make this should come on, work again. It's like if I don't move them long enough, they start freezing. We talked about updating. Um, the standard rule for updating is every 5 years or when there's a health event, when there's a life event, or if you're getting more seasoned in life, once a year, right? You want to look at it to make sure, right? I had situation like with my brother, perfect example. A life event made me evaluate this was not the right person. So that was a good time that I wanted to check it and make sure it's right. Um, Also, this is something I 90% of the times you've got siblings from like these old estate plans. I've got estate plans we're administering from the 80s. And you know, they drafted them when they were retired. So retired estate plans from the 80s, you've got very old people listed at this point. And you know, I can't tell you how many times, well, my Aunt Sarah can't do it. She's got dementia in, you know, Kentucky. I hear that all the time. So you always want to make sure that to the extent you know that your loved one is named as, you know, someone's agent under a power of attorney or their trustee, that you kind of do something in advance because you have the ability to, right? Just because you have a diagnosis doesn't take away your legal rights. That's what I do. If you want to know what I really do, I do that. I run in and make sure that your wishes are upheld as long as possible. I make the joke. I'm afraid it's going to happen to me, obviously, so that is why I do it. But it is important that people have the right and dignity to stay in charge, which also means the dignity to resign, right? I tell people you don't just get to come in and take over someone's life. They're still part of it. You know, sometimes unfortunately there are, you know, Alzheimer's and other types of major neurocognitive disorders that create paranoia and other difficult behaviors. And those ones are the ones that require a little more usurping of wishes. But there's also a lot of time where you can learn to communicate in a certain way. And that's what Alzheimer's San Diego can provide. You have a resource that no one else in the country has. We have phenomenal educators here in our programs that can help you create very, what we call therapeutic fibbing options, right? To the extent, rather than forcing mom out of the house, can we show her some black mold underneath the sink that may have been spray painted on? That is like, hey, why don't we just go here for a little while and get you out of the home? There's so many options. So it's important to make sure that you've got the people in place that are going to do this. You also want to update and check beneficiary designations. I'm not saying that it has ever happened, but you know, we are in a land and a world in which their companies are constantly changing software. And if they move one software to another software and the beneficiary designation does not follow, you may have a probate problem or at least a litigation fight on your hands to have them enforce it. And I can tell you, nobody keeps their old beneficiary designation forms laying around. And actually, I have that situation right now. We've got a probate of of, I don't know, I think 400, $500,000 because the beneficiary designations are not, they're not to be found. So even though there's a trust with all of the assets, we still have this ancillary probate over here. And then please make sure somebody knows where it is. There are attorneys, we have a listserv where we all communicate. And in that, there's a lot of attorneys saying, if you've done an estate plan for Mrs. Jones, please let me know, because people can't find them, but they can find that the house is in a trust. So I'm not saying let people look at it. This is your private business, but let them know where it is. So if I get hit by the bus, it's on the second shelf in the office next to the, the cat picture, whatever it might be. Okay. So the question really, this is a good question about how do the docs differ if you're married. Being married means nothing when it comes to your legal rights. I know a lot of spouses that specifically do not want their spouse to have access to things. So the law also agrees with that. During COVID was when, again, it came out because I would have calls saying, help me, my husband of 64 years is in the hospital. I don't know if he's alive or dead. Right? So there are people that will allow and take pity on the grieving spouse, the crying spouse, the upset child at the hospital. But they're breaking the law by giving any information. So what'll happen is that, and there's a definitely financial, try to access, your spouse's bank without being on the account. They won't let you either. So you need to have dueling, meaning joint. I have a power of attorney. My spouse has a power of attorney. We hopefully nominate each other. You don't have to. I see that a lot. And then whoever we have after. So you do need to have these. Nothing defaults to the spouse. In fact, there are so many cases out there that kind of demonstrate why it doesn't. They're never good, but it does. And so the law doesn't provide. There's a question about advising individual powers of attorney for specific entities. There are a lot of very difficult financial institutions, and I will say that I was the head of compliance for a financial institution at a time in my life, and I made the rules to protect my client, which was my bank, not the customer. So all banks do that, all financial institutions. So sometimes there are some that are much more difficult than others. So if there is a specific financial institution power of attorney, go ahead and fill it out. That's not going to hurt you. The only way it could hurt you is if you change your mind on that person. So that's the only real issue. So what I like to do is I recommend that if you've got, to send the power of attorney you have to the entity and say, do you accept this? And this way, if it does ever get revoked or amended or changed, then we can submit the next one and you won't forget that you have it. So somebody said they provided the advanced healthcare directive to the private physician. Is that enough? Well, it's enough for that private physician, but what happens if you're in a car accident and you go to a different hospital? What happens if you're out of town? So you always want to keep them with you. Paramedics are trained to look in the glove box and and your fridge and the side of your fridge. Those are the places they're trained to look for them, just so you know. Okay, so I'm trying to look to see if there's anything this part specific. Okay, and so again, referrals for this, Alzheimer's San Diego has a very good list of referrals that they recommend. They're generally really vetted and have been doing this a long time. My office also has some referrals for you. So you can find them. And then let's see, my father's misspelled my middle name and is trusted on the durable power of attorney. Does it invalidate it? Okay, if your name is not correct, it is an issue. We want to get that amended. You want to call the lawyer and see if they can do a Scrivener's error, only because you have to show your ID. And if they don't match, that's a problem. So dad can do either an amendment to it, or maybe the attorney can even do something. I would reach out to that attorney that drafted it in the first place. Okay, so and then somebody says, if they have a trust and their husband's been diagnosed with dementia and Parkinson's, how do we remove our executor? So Though that is a very case specific, you're going to need to meet with a lawyer because a lot of times powers of attorney allow for specific changes that are not going to change your beneficiary designation. So if it's just that kind of change, so that's some more advanced planning that I need more details on. And if you live alone and don't have anyone to be trustee, I don't have anybody to be my trustee. And so there are professionals who do it for a living. We can always get you a bunch of referrals. There are some phenomenal ones in San Diego. I love them because not only do they do this for a living, they're better than family. Um, the idea is if I get hit by a bus, somebody needs to access my assets. Let's say I pick my brother in New York, ER doctor. He doesn't have time to fly out here. And if he does, he doesn't have 7 hours to sit at a bank to try to get access. But if I pick a professional, she's got a friend at the estate department that she can just call and fax over my trust, my letters of incapacity, or my death certificate, and she has access within 45 minutes. Big difference. And that's kind of why I like it. Most people don't like it because it's a stranger. So, there's a lot of balancing that you can do for that. Okay, so I'm going to move on because I'm afraid I'm going to run out of time if I keep going on this, but we'll always be able to come back to the more questions. If I can get the slides to move. This is so bizarre. I'm afraid to push it again. Bear with me. So I'll keep answering while I'm trying to flip the slides. Um, Okay, so what is long-term care, right? You hear this a lot. We talk about long-term care. Long-term care, it's also known as custodial. And when we say custodial, because that's how they talk about it in skilled nursing facilities, that it's important that you get familiar with the nomenclature, the definition, so you don't feel like, because you're already in crisis and there's some skilled nursing facility trying to kick you out saying, we don't have any custodial beds, we don't have any custodial beds, we don't have any custodial beds. I hear that more often than not, and I say, well, the bed they're in right now looks just fine. So long-term care really is the services and supports and care that are non-medical. Think of the idea of when this is coming. You have a health event, you end up in a hospital, you're discharged to a skilled nursing facility. Medicare is covering that. So you're in skilled nursing based on some sort of rehabilitative type. So we only have rehab beds. We only have rehab beds. We only have rehab beds. You'll hear that. Well, in the event that that facility not only accepts Medicare, but it also accepts Medi-Cal, then every bed in that facility is a rehab bed and a custodial bed. Custodial beds will be the ones where I no longer need skilled level of care. I'm no longer receiving occupational therapy, physical therapy, speech therapy, wound care, intravenous drugs. That's skilled level of nursing care. If I'm no longer receiving any of those or benefiting from them, meaning I just can't go in and get physical therapy for my knee because I don't need it. Or in the land that we're in right now, a lot of patients who will benefit from occupational therapy or physical therapy are non-compliant. And so if they're non-compliant, they just can't stay in the skilled bed. But if it is a facility that does take Medi-Cal, they can stay in the custodial side. And when I say side, they're not supposed to have it, but we'll get to that in one of the next slides. So costs of long-term care. Medicare is not going to cover this. Okay, everybody thinks it does. Medicare is an insurance company. It is not a long-term care company. So what is it? So there's community-based care, which is what we all want. And that's in-home care. You can supplement your in-home care with adult day programs because a lot of people are still working, trying to take care of mom or dad, or just need a break. Like I can't do it all day. I need a break. And so I can handle evening and nighttime, but during the day, I need a break. And so there's a lot of options. It's not one size fits all. There's not one solution only. So you can always look at the in-home care versus the adult day program. PACE. PACE is a Medi-Cal program that is like an all-encompassing. And through the PACE program, you're going to have driving options. You're going to have respite options. You're going to have day program options. You're going to have managed care options. You're going to have all sorts of support that you didn't know existed. And so to the extent you can get qualified, you should always try. Then there's residential care. And this is what they're residential care facilities for the elderly, RCFEs. There are three names that we use in the world, right? We call them board and cares, which are also six packs. You'll hear that. They are the residential houses in regular neighborhoods that have six patients or less, six residents or less. The reason they exist is because there's an exception to HOA rules that says you can't run a business out of your home. That is why they're named something different for us. The law considers them residential care facilities for the elderly, but they're called board and cares. Then there's assisted livings, which are the apartment-like settings that have the restaurant and that kind of thing. And then there's what we call memory care, which is still just a residential care facility for the elderly, except we've termed it medical or memory care, but it really means a assisted living facility that has a secure placement or locks on the doors or delayed egress, meaning that you can't leave, an alarm will go off for 15 seconds, that kind of thing. And then there's skilled nursing, which is there's long-term care in it, either at a skilled level in the short-term rehab, but most of the time, skilled nursing care is when we talk about it, skilled nursing facilities, it is long-term Medi-Cal beds, meaning they are just custodial, room, board. You're not getting any real medical, but it is more oversight and in a higher level. I'm going to say this over and over and over and over and over. Medicare does not cover costs of long-term care. I can't tell you how many people tell me, I'll be fine, I have Medicare. I'll be fine, I have Medicare. Medicare covers, I'm trying to think if we have it here. Medicare will cover up to 100 days in a skilled nursing facility after a 72-hour, a 3-day hospital stay. It will cover 1 to 20 days at full price, and then 21 to 100 days at 80%. And your co-insurance, your supplemental insurance is going to cover the difference, but usually at like $175 a day copay. So, and then after the 100 days, there's no more coverage. It's important. It also only will cover maybe 2 days of in-home support, and that's like a nurse that comes for maybe an hour. So how do we pay for it? Most people, personal savings and assets, right? I was just asked 2 days ago by another lawyer in town if I have long-term care insurance. I said I missed the boat. It's almost impossible to buy it right now because it's cheaper to self-insure. It's cheaper for me to put money into a savings and let it grow than it is for me to buy a long-term care insurance policy based on the current numbers. There was a big, if you have it, that's great. Don't lose it. It's just very difficult right now in order to get it based on they're trying to fix the actuaries. People are living too long. Also, there's a lot of financial tools out there. So reverse mortgages, they are a brilliant plan if they work in your plan. And that is a limited set of plans. The reverse mortgages can be utilized very inappropriately, and you need to be very mindful when you're doing them because you will be eating up the largest asset you have, and you need to figure out why. I usually recommend not taking out lump sums because that money the interest will compound on the lump sum and you will eat away your equity. If you need a reverse mortgage, ask for the numbers for a line of credit, meaning that I only need $2,000 a month. Can I take out $2,000 a month? And then interest only builds on that $2,000 a month, not the $500,000 that you took out. If you have appreciated assets, a lot of people sell appreciated, they have the rental house or they had a business and it's highly appreciated, and meaning that when they sell it, they're going to have a massive capital gain tax. And so they're going to lose a substantial amount of that equity based on taxes. There are charitable gift annuities that are available, which are a phenomenal option because you can avoid paying that lump sum of capital gains and utilize that money. And in the long run, you can be altruistic and you can leave the charity the money in the long run. And so I love it because it serves two really good purposes. And I know I've done this in my old planning days, especially, and I know we've done them for San Diego, for Alzheimer's San Diego, and it's been great. But like you can choose the charity, but you get to utilize it during life. So it's phenomenal. Converted life insurance. In the olden days, you couldn't do this. You couldn't sell life insurance, but there is a way to do so now in order to pay for care, and it's a great option. A lot of people, when they start having these really high expenses, that's one of the things they stop paying for. Don't stop paying for it because you can sell it. Usually, the people that need to sell them or need to stop paying them are later in life. So the older and more closer to death you are, the higher value you're going to get for your life insurance. So don't just stop paying, inquire as to whether you can sell it. Then we've got Medicaid, which in California we call it Medi-Cal because we're special. We're not the only special state. I always say Massachusetts, they have MedMass, but it's all Medicaid. And there's also Cal-AIM, and then we also have VA benefits, which are also options. So I'm kind of gonna walk through the Medicaid. We're gonna go a little more detail in it, but I just want to make sure that people understand that Medicaid is not Medicare and that they're two different things. And Medicaid is, there are lots of different Medicaid, Medi-Cal options out there, and most people think of them for indigent or other types of like health insurance. And there's a long-term care option to it as well. And then VA benefits, the same thing. For the VA, you have long-term care options, you have medical options, you have skilled nursing options. So there's also, and they'll have day programs and also respite. So we always want to look at that. Tax deductible expenses. One of my favorite games to play in doing long-term care planning is with your CPA. I always say, go play with your CPA and your financial advisor and let them go play. You want super geeky ones, right? And I always say, if your CPA is not super excited about playing with numbers, you need a better CPA. Like your CPA and financial planner should geek out together and figure out how to best maximize your tax deductions based on long-term care. Because when you're paying for long-term care, that now is a medical expense. And so there are things like IRAs, which thanks to the Secure Act, nobody wants to inherit an IRA anymore. You have to pay it out in 10 years. So I have to absorb all of the taxes, the income taxes of somebody's IRA if I inherit it over 10 years. I don't want the taxes. Please don't give me tax-free money. I don't want your taxable money. I mean, I'll take all your money if you want, but if I have a choice. So this is the time when we want to talk to our CPA and say, okay, how much can I deduct from my taxes based on these medical expenses I have, my caregiving, any improvements I've made to the home for medical expense, those kind of things. And if so, how much can I pull from my IRA or 401k and offset so that magically I'm now using that money tax-free. So really you're gaining money at that point because it's the best way to do it. So there's a lot of different ways to utilize when you get ill. So what are these expenses? In-home care, so custodial or skill, residential care. So if you're in a memory care facility or if you're in assisted living, non-covered medical expenses, personal care items. So we start needing, depends and everything else. Durable medical equipment, we've got oxygen, we've got all sorts of things like that. Home modifications, you've got to get the wheel-in shower, you've got to make the doors wider in order to get the wheelchair through. And also long-term care insurance premiums. People, I think, forget about those and to deduct those. One of the biggest concerns that I've seen is when we've got early onset. I've seen it, unfortunately, it happens too late, right? By the time they get to me. And either they've been taken advantage of or they've lost their license or they've been fired, things like that. What do we do if a diagnosis of dementia has been, we have it, but we haven't disclosed it? What do we do, right? And there's a lot of companies out there that have these unknown long-term care insurance or short-term or some sort of disability options that will pay for some care, which is incredible. So your larger corporations, who knows what you're going to have available, but it's a disability. And so you can request accommodations. I had a veterinarian who wasn't able to do surgery anymore, but he sure was able to do a lot of things with those animals that was still within his ability to practice as a profession. Did it take a pay cut? Yes. But did he still have somewhere to go every day that was fulfilling? And did he keep a lot of his dignity until he couldn't? Yes, he did. So there was also the employee assistance programs, short-term disability benefits from, I'm telling you, from some professions is a lot higher than I've ever really thought of. And then other ones have long-term disability insurance. There's also the family medical leave benefits, which is something that as the caregiving spouse, child, you need to think about. And then there's also early retirement, right? I mean, we need to talk to the employer. If you hold off and hide it, then you're going to get fired and they have no repercussion. If they fire you because of it, then they may have created a claim that you have for them. So, I mean, maybe that's what we want. Um, there's also the compassion and allowances that I think a lot of people have missed over the years. So, share this one with people as well, because it will expedite the process of getting SSDI. SSDI, Social Security Disability Insurance, is how do we say it? There's a difference between SSI and SSDI. Supplemental security income is a minimum amount of money that the federal government says you can have if you have a disability, right? It's just like you don't have a work history, we'll give it to you. SSDI is getting your Social Security benefits early. You don't have to wait till you're 62, 60, whatever year you're going to turn the ages, right? The Social Security's now made it not as easy for me to say this because it's not uniform anymore. But it's if I have become disabled and I have not reached the age of retirement, I have paid into my Social Security and I'm allowed to get it back if I can prove a disability. So my SSDI is something that I can get regardless of my assets. So I make the joke, Bill Gates is entitled to SSDI. He's not entitled to SSI because he's got too many assets. And so what this does is it allows it to expedite the process. So it applies to young onset Alzheimer's, FTD, frontal temporal dementia, primary progressive aphasia, progressive supranuclear palsy, Lewy body, ALS, Parkinson's. I mean, these are the things that come into my office all the time. So they get the expedited treatment. So we're gonna now talk about the veterans benefits. Before I want to just double check because we're kind of moving topics. So I do want to look to see. Um, okay, so there is a question on long-term care insurance that goes up every year. Should we still keep it? That is a very personal decision that I cannot answer. Um, I can tell you that it's a math problem that you guys need to work out with yourself, your CPA, your financial planner, because you paid in. Obviously, it's an insurance company, so they're trying to get you to not pay for it. I know personally, my aunt, hers kept going up, and we're glad that she kept it, because she does utilize it now, and it's really making a difference. But I don't know; it's a very personal decision. Um, Okay, we've got mom has a will, but is probably 30 years old. She has since lost assets and now has dementia, doesn't need to be updated. 30-year-old will should probably have been relooked at, yes, but depending on where her cognition is, I don't know what she can and cannot update anymore. Again, capacity is a very personal and specific thing, so I can't answer that, but it should at least be looked at to see what it says. And then what about long-term care products that are basically like life insurance, but for long-term care and they have a death benefit? Okay, so I'm not telling you what to do with your money and I'm not giving any financial advice here, but that's the only thing I can purchase right now. And I keep looking at them myself because I like the use it or don't lose it options. And so long-term care insurance has that. They have where you can buy a life insurance policy that also has a rider for a long-term care insurance such that if you need it during lifetime, you can draw off of it during lifetime and utilize it and there'll be no life insurance. But you know what? That's better because my children would rather have me have caregivers rather than leave them an inheritance, I think. We'll see, but I think that's what they would prefer. Um, okay. All right, so veterans benefits. Veterans benefits, they are broad, and everyone in the world, in my opinion, has a different experience with the VA. Some are good, most are not good. But we are in San Diego, and so ours are usually better than the average. There are health insurance, there's medical care, there's service-connected disability income, there's pension benefits, there's traditional, and there's non-service connected, and then there's death pension. So health insurance. At a minimum, if you need a hearing aid, use your VA benefits. That's save yourself some, $6,000. They will do it. We do have good VA medical insurance when it comes to the medical care here. But we are unique in that. So I actually think it's a good idea. I also have my girlfriend alone. She's been waiting for 2 weeks to get in to see somebody with her TRICARE for she hurt her finger. And you know what? She could be missing her window in order to get the surgery that she needs. So I don't know. That is the positive and the negative. But when we talk about this world, when we're talking about long-term care, the VA has a lot of options, right? As people age, so in the world of veterans, there is service-connected disability, meaning that during my time in the service, I was injured. I didn't have to get shot for that. I could have been playing basketball and twisted my ankle. Or I have one client, he went into a burning mechanic shop and pulled out like the guys and he burned everything and he's got this massive arthritis from it now and he can't use his hand and they are able to connect it because of the damage that happened when he was 22 years old. And he is now 100% disabled, rated disabled, that it showed up 50 years later. Um, because he was injured during the line of service, right? What happens when you're in the VA or when you're in the service is you're in the service. It's a 24 hours day, 7 days a week, 365 days a year. You don't get to just take a vacation. They frown on that. They call it AWOL, right? So anything that happens while you're on duty, meaning in service, is a service connected disability. So a perfect example, I always like this man couldn't, he walks into my office, he was, I don't know, 70, 68, 70, not old. And he's hunched over, he could barely walk, and he's telling me about, yeah, when he was 18 at boot camp, I can never I can never remember, at he was either a Marine at the Air Force camp or Air Force at the Marine, and they thought it'd be funny to put extra charges in one of the like emergency parachute things. And it shot him up, broke his back. He was fine. He recovered. He was, because he's young and viral, he was fine. But what happened is as he aged, his back started to curve and now he's completely hunched over. I was like, sir, can you go please and get yourself rated from the VA? Well, it happened. I said, I don't care. He now gets $8,000 a month. So please do so. If you have anything, if you have a rating and you know what that means, you can go increase it as you age because that rating probably is going to go up. So that is what those are. And what's great is that if you have a surviving spouse, they're also entitled to get a DIC, which is dependent indemnity compensation after you've passed. So that's really good. So these are the real traditional types. I mean, and then also pensions. I mean, if you worked for the VA, if you put your 20 years in, then you get your basic pension. But there's also the non-service connected pension benefit. That is the one where I served my 2 years and I'm in and out and nothing happened. As long as you served one day, 90 days total, and one day, 90 days of active duty. So the reservists have problems with this, but 90 days of active duty, one day of those during a wartime period. Wartime periods are a lot longer than you think. You don't have to be in service. You can have been sweeping floors in San Francisco. But one of those days we were during an active wartime, then you're service eligible. You will, if you're financially eligible, which they have a calculation that is based on income plus assets together. So that is just an evaluation you need to have done by a VA attorney. Um, or the VA benefits department themselves. And if that is the case, and then when you are receiving care and or any type of medical expenses, they will reimburse you. So they will not just give you money. They will give you money back if you spend more than, let's say, $1 more than your income that month. They will reimburse you based on whether you're an individual, whether you're an individual with a spouse, whether you're an individual spouse and kids. So that's the how those benefits work. So you always want to look to evaluate whether that is something that is an option or not. And so when I say the death pension, that is also, so there are surviving spouse benefits as well. And let's see if I can get these slides to go. I don't know if it's just my internet today or, okay. There also is something that, again, San Diego, we have a lot more options, I think, than most places. So if you're watching this from out of town, I don't know what is in your local, but we do have very good caregiver support programs, meaning that there's adult day health programs here. There are also, it's interesting because how it will work, I just can't say how it works for everybody, because if you go to the benefits department, um, actually, no, you go to the medical side. Okay, bear with me on this one because it's very difficult. The VA medical does not talk to the VA benefits, and that's really confusing. The computers, I still don't think connect. So you can have a medical issue that doesn't get to the benefits. So you can have a social worker over in the medical side. They are the ones that can help you get some additional benefits because it's based on, which is terrible, but it's based on their opinion of what you need. So I always say, be nice and you'll probably get more. Because I had a client who ended up getting a voucher for $20 a day adult daycare. And so she could then put her husband in adult daycare from 8 a.m. to 3 p.m. every day for $20 a day. That saved their basically their financial life, because now she could handle him throughout the rest of the evening, but she needed a break. And it allowed him to stay at home, and allowed her to be the primary caregiver. And so we also have home-based primary care program where they do also provide options at the home. And so you want to see what's available. I love the homemaker and home health aid program because then you can also get some support that is also in the house. Telehealth. I mean, a lot of times people are killing themselves getting in and out of facilities, in and out of the car. Let's try to work with what's the option. Respite. If you don't know what respite is, it's because you need it. Respite is a temporary placement. You can have a day off, you can have a weekend off. I have a lot of caregivers who have never, they're missing weddings, they're missing births of children, they're missing things. They're losing their mind and not going out for a weekend with their girlfriends or a golf tournament or whatever it might be. And the temporary placement's okay. Your loved one with dementia is allowed to go on vacation too. Some of these places, some of these temporary placements, I mean, it's like a little vacation too. It's a staycation for them. There's also skilled home care services, so you can keep people at home longer when the nurse will come to you, and then always hospice options is always a good idea. Okay, so we're gonna go through a lot more of this Medicare, and I'm like, I think we got an hour, so I think I'm doing good on time. Okay, so Medicare. What is Medicare? Right? I think it's important that we understand the basics. It's a federal health insurance program, right? It pays for your doctor visits. It is not based on financial need. That is going to be your Medi-Cal. So what it is, Part A, hospital, it covers your hospital stay. Part B, it's your medical insurance. It goes to the doctor. Those are the things you get. Now, Part C, D, and F, G, and N are supplemental, right? You can have, there's private health insurance. Part D was that donut hole. I don't know if you remember that. I think I'm just maybe old enough to remember. But, when there was the donut hole conversation, when this came into place, this is the drug coverage. And then there's the Medigap and the supplements. And so you, depending on the supplement you have, a lot of people, when you start this, and I mean, if I can kind of help people when they start, we are now, because of the ACA, Obamacare, we're really used to no pre-existing conditions. But when you pick a Medicare plan, that doesn't exist. That they can still discriminate based on pre-existing conditions in Medicare. So when you retire or you get Medicare initially, if you pick the lowest option when you're looking at your healthcare, You can't go up unless you haven't had a health event for 2 years. And generally at that age, you're going to have something, right? So if you get the Cadillac and you go down to, I can't think of like, what's the Pinto, right? You can't go back up unless you've had 2 years of no health insurance or no health events. So be mindful of that when you're picking a Medicare program. But again, Medicare, you see hospital and medical insurance. You don't see any long-term care there. Um, Sorry, I'm again trying to wait. But that's when Medi-Cal shows up. Medi-Cal is Medicaid in the state of California. It is a needs-based program and it is funded by the state and federal funds. So you're gonna hear me. Keep I'm gonna try to keep my mouth shut for as much as I can on this one. Um, because when we have a state and a federal government that do not get along with each other, it really created some problems in our Medi-Cal world and a lot of uncertainty for quite a long time. But we at least have some sort of certainty as of right now, but it's only been about a month and a half of certainty. So, but it does provide free or low cost health coverage for children and adults with limited income or resources, right? This is what most people are thinking about Medi-Cal is like free or low cost health coverage. I mean, that's what we think of. It also has the other services like the WIC, like the food stamps, those kind of things. And it will pay for medically necessary healthcare services, even if you do not fit within that program. But what we're going to focus on is the long-term care. I remember when my father died because they didn't die in the right order because my dad was supposed to have a long life. Um, their financial plan was not well thought out. And my mother and I had a conversation about Medi-Cal. And part of it was she had the stigma with it. And I really, really worked hard to get her to take that stigma away because Medicare and Medi-Cal were created right around the same time. And Medi-Cal, when you read the legislative history, the purpose of it, the actual purpose of Medicaid, which is our version of Medi-Cal, was to end the pauperization of spouses. That's what's in the legislative history. That's how that was the conversation in the 70s. They used those words, right? But the idea was the testimony was, husband gets Alzheimer's, and wife spends all the money caring for him, and then she's homeless eating cat food. And so that's what Medicaid, our version, Medi-Cal, was created for. It was created to protect the spouses. And then later in the legislative history, you also see that it was intended for wealth transfer. It was intended to preserve the home in order to keep the next generation off of public benefits or, as a generation as a whole. We were starting to see part of because we were leaving these generational houses, but we were starting to see that the cost of medical coverage and long-term care were separating and people were becoming destitute. And without any wealth transfer, that means the next generation also becomes destitute just based on basic inflation. So that's why we have Medi-Cal, which version of Medicaid. So we are unique. And when I say we are unique, we are very unique. So whatever I'm going to say today, if you Google me, you're going to think I'm lying because you're going to read something from Massachusetts or from New York or from Michigan or from Nevada. And because of that, it's not going to make any sense. And I'm going to give you a really good resource at the end as to where to go to kind of confirm that I'm not a crazy person. Well, that doesn't confirm I'm not a crazy person. It does confirm that what I'm telling you is the truth. So, but it does provide protections for the middle class. That's really what this is for. And so people think it's some sort of poverty protection program, and it's not. It is a poverty preventative program, yes, but it is for the middle class. It was created for spousal protection, and it allows for some wealth transfer, and it provides the public policy of California, right? When Reagan closed our institutions, he instilled the public policy to keep people out of institution. A skilled nursing facility is an institution. So the public policy is to ensure that people stay in home, which is why we have in-home supportive services. We have community-based adult services. We also do have skilled nursing that's covered, but we also have an assisted living waiver, and assisted living is considered home or community-based, just to give you a little idea. So who is eligible? There's multiple ways to become eligible. There is the most common way that people think of, which is if you're eligible for SSI. And remember, I said SSI is supplemental security income, which is the minimum amount of money the federal government says that every person should have if they are disabled and unable to work. You become automatically eligible for Medi-Cal. Very simple. You don't have to do anything. If you have income and it makes them ineligible for public benefits, you can also become medically needy. And that means that, like, I had a client, I think that their sons, he had a very rare disease. I mean, he actually outlived his life expectancy for a very long time, but he needed a medication that cost $1 million a year because it was such a rare disease, and Medi-Cal covered that, which is incredible. But it's important to know that it also has share of cost, and there's also potential estate recovery. So what it's going to do is under today, and I think I put this in. Yes. So I'm going to kind of, this might be too much information, but there's so much information out there when you Google it right now, because there's been so much that has changed over the years that I need to kind of walk you through this so it makes more sense. So in 2022, there was a bill that was presented. And what it did is it slowly eliminated the asset cap for eligibility. In every other state, right? This is every other state, 49 other states. In order to be qualified for Medicaid, you can have no more than $2,000 in assets in the bank. And you can have a residence. And I think some states have incorporated the equity cap of 750. I'm not positive because I don't practice in other states, but at one time I know that was it's part of the rules. I just don't know if they've implemented them or what states have. That you can have an IRA, so any type of individual retirement account, 401k, those kind of things, so long as it's in a payout. And then you can have a car, and then you can have some sort of business, but that there's some really finite rules with that. That's what every other state is, and that's what California actually had as well. Then in 2022, a rule passed that raised that asset limit of 2,000 up to 130,000. But it was a staged program such that on January 1st of 2024, the asset limit was extinguished completely. So may hear about people who have, 500,000, $1 million, $8 million in the bank, and they're qualified for Medi-Cal. It's because between January 1st, 2024 and January 1st, 2026, there was no asset cap such that Bill Gates would be qualified. And so when I was teaching during that time, I used Bill Gates, not because I know it's for certain, but I read an article once that he has zero income, right? That because he doesn't own things properly, like the way, just nothing's income producing. So that he may have billions of dollars, but he has no income. So according to the Medi-Cal rules during the 24 to 26 time period, he was qualified for Medi-Cal. Then in May of 2025, you may have heard Governor Newsom say, oops, we're $3.4 billion upside down. We need the federal government to bail us out. Then you've got the Trump administration saying, go pound sand. You did this to yourself by getting rid of your asset limitations. You need to re-put it back in. This went around and around and around. And finally, on December, I think it was 22nd, 23rd of 2025, the federal government approved California's change to implement the asset cap back down to 130,000. So we are different than every other state, meaning that as of today, we have an asset cap of 130,000, not 2,000 like every other state. That was a lot, but it really kind of comes down to that's just the standard. So let's see, I think, yes, because I see a question pop up, is the asset cap for the person or for the couple? We're getting there. So now that we've established that was for the one person, that one person is entitled to have $130,000 in the bank, meaning cash assets, non-retirement. So it could be investments, it could be stocks, it could be bonds, it could be, other type of investment schemes, but no more than valued at 130,000 outside of retirement. You can still have that retirement account. So you can still have $1.8 million in an IRA, and that's still fine. You can have your residence currently of any value, but keep in mind that the one big beautiful bill, I think I'm missing a B, does put a limit of $750,000 as well. So not only did the 2006 rules have that in place, now it's going to be implemented. I keep telling everybody, hold on, because the advocates are working on getting an exception for California because everybody who bought a house in when they were in their 20s or 30s now has a house that has got well over $750,000 in equity, just as a general rule here in San Diego County, and anywhere in California. So New York and California are going to be fighting that a little bit more. And since it's not implemented until 2028, I say hold on. Don't get too excited yet, because again, there's a lot of horse trading that goes on in this world when it comes to politics, because this is a political issue, just so you know, and it shouldn't be, but it is. So that is why I focus on a lot of this. That's why I don't do the boots on the ground as much anymore, and I kind of focus on working with the legislatures through this. So we've got the spousal protection. So I do have a question that I think I want to answer. So are things in a trust considered for the Medi-Cal gap? So a trust, I'm going to rewind back to what a trust is. A standard revocable living trust, which is just the standard trust that we have, is a probate avoidance device and a Medi-Cal recovery device only. It is not an asset protection trust, because this is why people get really upset. They don't want to do a trust because they don't want to give away their assets. They're not. When you put your assets in a trust, they're still yours. It is still governed by my social security number. It is still taxed to me. All I did was put it in my name, comma, trustee. I didn't take it out of my name. There are elder law attorneys who do asset protection trusts for Medi-Cal and VA planning. They will take the assets according to the rules and according to your risk factors, and they will move assets from someone's name into an irrevocable trust such that they will not be countable. That is not for everyone. I do not want everybody here sitting there, oh, we need to go do that. The reason why it's not for everyone is because you have to have the right family dynamic, number one, because you're giving away your assets. And then you also have to make sure that you're not incurring capital gains. You have to make sure that the math works out. You have to make sure that you're doing it properly. Do not do it on your own. You must do it with proper legal counsel, because most likely, if you try to do it on your own, you will be prohibited from doing anything. And we're going to get to transfer soon. So the next question is, what about joint accounts? And so we're going to kind of talk about this with spousal protections. How do they determine what is mine and what is my husband's? This is how it works. So in addition to the 130,000, the well spouse, so we're going to call that the sick spouse, and we're going to do it this way because, again, this was intended to protect spouses. You've got a well spouse and you have a sick spouse, and the sick spouse can have $130,000 as well as a residence, a car, an IRA, and then a business that applies under the exception, and then a couple minor things. By the way, before I forget, everybody here has heirlooms. We no longer have jewelry, right? Jewelry is a countable asset. Heirlooms are exempt. So everybody has heirlooms. So the wedding ring is an heirloom. Diamond earrings are an heirloom. The tennis bracelet, the Rolex, all of those are heirlooms. They are not jewelry. Okay, so something called the Community Spouse Resource Allowance, the CSRA. I will acronym you to death today if you really want me to, but it is the amount of countable non-exempt resources. What does that mean? It's cash in the bank, it's investments, it's stocks, it's bonds, it's your money market, those kind of things, not your IRAs that the well spouse can have. So you've got $130,000 for the sick spouse, $162,660 for the well spouse. So in the joint bank account, you can have $292,660 and still be qualified. What will happen, and this applies, so you're asking, what about a joint account? You can still qualify for Medi-Cal with that amount in the account, But Medi-Cal will send a letter saying you have 90 days to get the sick spouse's name off of that extra 162,660. I've always found it interesting because Medi-Cal, a government agency for the state of California, will send a letter that specifically says steal from your spouse, but you have the family code that says if you steal from your spouse, it's a crime and you're stealing and you breach your fiduciary duties. So that is kind of part of one of the reasons why when doing your estate planning, you kind of want to talk about this, right? You want to say, hey, if I get sick, I want my spouse to transmute, to take my money from me and give it to them in order to qualify me for public benefits. And that's something that most estate plans will have when talking about long-term care. So I hope that helps. So that is the value that you can have. You can have, as a couple, a combined 292,660, right? The 130 plus the 162. And then you can have IRAs, one residence, right? You can't have two. People are trying to do that, but it's one residence among the couple, one car amongst the couple, and then that business that I kind of talked about. So then that's how you qualify asset-wise under current rules. The income, what do I need? How can I qualify? Minimum monthly maintenance needs allowance. So the current income, it's always going to be 138% of the federal poverty level. That's for the sick spouse. So I think we're at 2,000-ish dollars. I'm just going to round it out because there's so many numbers coming at you. Let's say they can have $2,000 in their name. And you're like, well, wait a second. My sick spouse, he gets $3,000 in income and I only get $1,000 in income. What are we going to do? And so there's something called the MIMNA, and it's the minimum amount of money that the federal government has decided that the well spouse needs to live. So when I say it's determined by the state, the federal government gives a max and then your individual states get to pick. So your Kentuckys and your Kansases might not be the same number because they have a different cost of living. But ours in California, we always pick the max, so it's 4,067. So in my scenario where you have the well spouse, we're going to call it the wife, right? The wife has $1,000 in income. The sick spouse, the husband, has $3,000 in income. You're like, wait a second, he's not going to qualify. How am I going to do this? What's going to happen? Can we qualify? And then he's got a share of cost, because usually the difference between your income will be your share of cost, which is like a copay for Medi-Cal. But Medi-Cal says, no, 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 no. We've got something called the MIMNA. We want to protect spouses. So they will allow the well spouse, the wife, to take the $3,000 from the husband and make it part of her income because it's below the 4,067. So that is kind of how that works. I can't remember what the next slide is. Okay. So I'm going to give another kind of math example of how it works on the reverse. Let's say that the well spouse is got a nice teacher's pension. CalPERS is $7,800 a month, and you've got the sick spouse who, self-employed, and he's got $1,800 in Social Security. That $1,800, he's going to qualify for Medi-Cal, but that full $1,800 is going to go towards his payment because the well spouse doesn't need to steal anything because she's over that 4,067 because she has $7,800. Does that make sense? So you don't get to take it in addition. The MIMNA is to make sure that the well spouse has at least 4,067. So I hope that part makes sense. And I believe the slides are available when this is over. I think Jean said that. Okay, so income. What does that really mean? So we're talking about like joint accounts and how does this impact if I'm married? One of the ways that we kind of get creative with income is that, let's say there's an annuity or some sort of payment that's coming in. It was either coming in jointly or it's coming into the sick spouse's name. If we can change the name on the check, and I'm not kidding you, this is an actual rule. I did not make this up. This isn't my nickname. This is the actual law. It's called the name on the check rule. And it allows what would we call the community spouse, the well spouse. to keep all of the income that's received in their name, regardless of the amount, right? I just said that we need to have the sick spouse qualifies based on their income. And if it's below that 2,000, then that's fine. So a lot of times the sick spouse, if it's the husband, generationally, they're usually getting more money still. And so if we can change those names, and so that's something where a quadro, the qualified domestic relations order for some support, comes in handy, because if let's say that the husband has a large IRA with a large required minimum distribution, that's a lot of money that's going to come out and it's going to kick him off of benefits. But if we can go to court and you don't have to get a divorce. I'm not a family law attorney. I don't dabble in it. I don't know anything about it. So I always assumed that in order to get one of these quadros, you need to file for divorce and have all these extreme situations happening, but you don't. You can just file for a quadro in the family court and say that you just want this and you want to do it for proper long-term care planning. And they will agree. And there's going to be a guardian ad litem appointed. So it's a little bit of a hurdle we have to jump, but it works. We also, like, one of the things that we can do as litigators, lawyers, so we also file 3,100 petitions, and that's to increase your CISRA. So we weren't able to do this with the weird rules because we didn't need to, but we are back to the ability to increase these, right? So if we're California, right, we have an entirely different cost of living than everywhere else, even New York. I think we're just different. I mean, because I just got back from New York and gas was 286, and I'm like, oh my goodness. Right. So just our daily life is a lot more expensive. Groceries were cheaper there, everything. So even though, yes, their property is expensive, everything else was not. So because of that, we can do a math problem. We need, just say, like, the well spouse. Based on my income, 162,000 is not enough. I need the interest from my $800,000 in the bank. We can file that petition and increase that number from 166,000 up to 800,000 or up to whatever. We just have to have it, just the math has to math. That's all. You need to show your expenses. You need to show that you can't survive based on that, based on those numbers. So those are very case specific issues, that it's hard to kind of say for each person, but it works, and there's no magic answer. I just hope that everybody's kind of getting the idea that we can get more creative. Okay, so transfers. You're going to hear about transfers. Other states, you cannot do transfers. If you can't even consider this if you're thinking of moving to another state, because there is a 5-year look back for all transfers. California, we have a 30-month look back still. Again, and this is all subject to change because I have no idea what kind of horse trading was happening in order to get our Medi-Cal covered. So the transfer rules exist, and the rules do say you cannot do it to qualify for benefits. You cannot intentionally impoverish yourself to qualify for Medi-Cal, but they also allow for stacked gifting. They also allow for transfers of assets over time that don't have a penalty. So this does require proper legal counsel. People always want me to do the math for them, and I always say no, because every person's different. And I have seen people come into my office saying, I did Medi-Cal planning for my mom 5 or 6 years ago. She still hasn't received anything, but man, was that expensive. And I said, what do you mean? And they said, well, we transferred assets around and I had to pay $136,000 in taxes. And I said, oh my God. In my opinion, that was wrong. It was wrong. And I told her so. Because number one, mom still hadn't received any benefits from it. And number two, why would you do that? Because now she has to receive, they paid $15,000 for a trust for the plan, $136,000 in capital gains. Is she even going to get that much in Medi-Cal? Because she's been caring for her at home and she's going to live there forever. So it didn't make sense. So don't let the fear kind of take over. It has to be a mindful plan, right? And this woman had the best of intentions to protect mom. But the idea is that we want to utilize the strategies that are appropriate for your fact pattern, for your family. But there are definitely available options. So again, like we are look back is 30 months. You can still do these stacked gifting. And there's also transfers of exempt assets that are not penalized. So this one applies to the VA too. Um, I will tell you a really good strategy is if somebody is looking towards selling their house and they want to get and to move into a facility and they have the appropriate family that fits this. The VA does not consider a home an asset currently. That I know will change eventually, but in the VA, you can't transfer assets without a penalty. There's a 3-year penalty, a 3-year look back. And there's no stacked gifting options where there's no exceptions to these penalties. But the home is still exempt. So if you transferred a home and then sold it through an irrevocable trust, those assets won't be countable and you can still qualify for VA. And I saw somebody's question, why would the VA take assets from you? I don't know what that means. I don't know if I misspoke, but the VA won't take any assets from you. They have an asset, they have a net worth eligibility cap, which would be your assets plus your income, and they cap out, and that's how you can qualify. So let's say there's only $50,000 in the bank, but so you're going to sell the house and net, $900,000. That money could be saved and utilized to supplement, and you can also benefit from VA benefits or Medi-Cal. So those are some options that you would want to talk about with your lawyer, with your planner, and kind of explore them. But people get very, very, very excitable when they talk about Medi-Cal, as they should, because when you apply and you get approved, even if I think before you get approved, I'm not exactly positive on the when you get the letter, but it's usually a yellow piece of paper and it says Medi-Cal will take back everything they paid when you die. And people get very excited about it. And you should be, but with proper planning, you should just say, oh, that doesn't apply to me. And this plan, and these rules have been in effect from January 1st, 2017. So this is not new. This is not exciting. What happens, and when earlier I had said a trust, and that's why I didn't want the person that said we only have $200,000 in assets. I don't want to say a trust isn't right for this exact reason, because a trust is a probate avoidance device, but a trust is also an estate recovery device, meaning that the estate, according to the new rules, means all real or personal property, other assets in the decedent's probate estate. What is a probate estate? A probate estate is the only thing that you have to go through a court proceeding in order to get access to. Meaning, if I don't have my home in a trust, how do my heirs sell it? They sign a deed. What can I do when I'm dead? Sign a deed, right? So that has to go through probate. If they can't get access to a bank account, that has to go through probate. So what did I say you do with a trust? You put your assets in it so that somebody can sign your name, meaning it's not part of your probate estate. That's why we do trusts, right? You can do so anything that's not in your probate estate cannot be recovered. That I just want to make that like overly clear. Um, there's alternatives to probate or to trust. You can do payable on death, transfer on death. All of these things just have to be, and I'm sorry, I am working from home and my children just got home and the dog is barking. Um, all of these things can be done, but they have to be done appropriately. And my favorite part about payable on death and transfer on death is that they work so long as your crystal ball is working and you know what order everybody's going to die in and they follow that order. My parents are the perfect example. I do this for a living, but they always thought of me that 5-year-old girl. They just never listened to me. But their plan didn't work because they died in the wrong order. And so, yes, statistically, they should have died in the correct order, but they didn't. Dad died first, then mom. And so it was supposed to be the reverse. So their plan didn't work. But if these new protections prevent anything in a trust and anything that's payable on death or outside of probate. But it also prohibits claims on the estates if there's a surviving spouse or domestic partner. So this is also a really big deal because if your spouse is receiving Medi-Cal and you have no planning in place and they die and you're still alive, Medi-Cal is done. They can't ever come after you. They can't come after you when you die either. And I think people have been told that by Medi-Cal and they can't. But one of the other big things, I have done a lot of Medi-Cal like recovery defense claims over the years. And I have yet to actually one time, it wasn't my case, somebody sent it to me and Medi-Cal was right. I've never seen it happen besides that one time. And I think it's just because it wasn't my case. But Medi-Cal has to provide a copy of what they're going to recover, and they're always wrong. And they're always wrong because they cannot keep their records. They're so wrong that we were able to get 420 something thousand dollars knocked off a bill once because they were double billing. They were billing for in-home supportive services as well as hospital, like acute facility. So I'm like, wait, was the person at home or were they in a facility? And this was for years. And they're like, well, they didn't notify us. I said, but you were the one paying the home caregiver. Were you defrauding the state yourself? We went back and around and we're like, okay, you're right. So that's part of it is there's a lot of recovery that's protected. So when I talk about exempt from recovery, so anything in your revocable living trust. And okay, so there's a question, but that's not apply. So anything in your revocable living trust, anything that's held in joint tenancy, anything that's so like a joint account, meaning that I have a house, a lot of people will have their house, me and somebody as joint tenants. The survivor wins on that one, but make sure that the survivor does something. POD, which is payable on death, TOD is transfer on death. The only thing that makes them different is whether they're like cash accounts or securities. It's just a change in the rules. Life insurance and retirement accounts. Those are also going to be exempt with the caveat that they have beneficiaries listed. So life insurance and retirement accounts, IRAs, 401ks, those should have a beneficiary listed. They should have a contingent or a primary and a contingent because again, people don't die in the right orders. And so those are going to be protected from estate recovery. Also, anything transferred prior to death, so they can't come after, things like that. And then one of my favorite things that I've utilized is the homestead of modest value. The fancy way of saying if the fair market value of your home is less than 50% of the average in the county, then it is going to be exempt. So we've used this regularly. So your county, San Diego County is a big county. We have a high number. I think we are the most expensive county in the state, possibly the country at this point. And so if you've got a home, East County, North County Inland, other manufactured homes, those are all going to be below 50% of the average price. Those are just exempt based on their own, but you will have to probate them. Not the manufactured home, there's an exception for that for probate. But when you probate, like we do a lot of them, but they're a windfall for us. Why? Because they're statutory fees and and it's something if you can avoid, you really want to. So the next steps and the resources that we've got, right? So next steps, gather the important documents, your income, your property, your investments, your savings, your insurance policies. The reason why you want to gather them. I am administering an estate right now where dad died. He had a trust. He's got lots of properties. Nobody knows where any bank accounts are. Nobody knows where the assets are. Nobody knows he's getting this income from some random promissory note. Nobody can find anything. There's a third wife involved. She's not giving any assets. This is a nightmare. As I said, I don't want you to ever have to come see me or people in my firm unless it's to administer the estate happily. We do that. But the majority of why I have to get involved is because people didn't do these things. They didn't compile everything. They didn't get an idea of like what it's going to look like. They I've got a conservatorship right now where it's just this woman kept everything so secret that when somebody found out, one bad cousin found out how much money she really had, she's being held captive by him. And we had to file a conservatorship to get access. And her friends that filed it, they're like, if we would have known she had this much money, we would have done this and this and this and this and this to protect her. They had all of this. So it's like, and her stuff was everywhere. Nobody could find it. And the idea is that the cost to protect her from herself far outweighs anything she could have done if she just would have asked for help or just done something in advance. And so that's why you want to get these trusted family members or friends involved. I'm not saying you have to disclose all of your things. And again, I see the worst in everybody. I do see the best in everybody. But I don't trust anybody further than I can throw them, which part of the reason why I have like professionals that oversee other professionals, and there's going to be a lot of fraud happening in order to take advantage of me. But I want a lot of oversight. And so keeping things too close to your vest, like per, also creates the same problem. So you want to make sure that you've told trusted family members, you want to make sure people can find these documents. It doesn't do any good to have them and not be able to locate them. That's a really big problem. I really need you to create them or update them. Update them. You know, most people, they created them when they had kids, 20 years go by, and they've got either a brother or sister in charge, or they even have the kids. When you're putting this together, this is what you're looking at. These are when I see things go south, it's because mom or dad, or mom and dad, kept their rose-colored glasses on when they were picking people. And for you children out there who are now starting to become the caregivers, I need you to understand that you're pre-grieving. You're when you start grieving, and you know, one of the jokes I make is when the kids are in college, I'm going to go get my degree in, you know, neuroscience because I want to study the impact of grief on the frontal cortex because it mirrors FTD, by the way. What does that mean? For those of you who are living that, you understand that it's impacting your ability to reason, even though you're capable of doing everything else in your life. So when you're grieving and those you caregiver children, you started to grieve, which means your siblings started to grieve, which means you all need to give each other grace because y'all are going to lose your mind. I am an orphan. I know what it's like. And when you are incapable of giving people grace, and I say that in a way of like, okay, that wasn't the nicest thing they just said, but they're also hurting. Or they're here, somebody at the office is saying, oh, well, my friend Susie's sister stole from her. So somebody's coming at you in maybe an accusatory way. Maybe you can give a little grace and be like, hey, I'm not the bad guy. I get it. What can I do to make it better? So when we're talking about updating essential documents, you as the maker of the decision need to look at everybody for who they are, not for who you want them to be, right? I see it and I get it. And you're like, I really wish this, I really want that. But we need to look at the reality because I get involved when people thought the best of their children. I get involved when people thought the best of their neighbor. I get involved when people thought the best of their siblings. I mean, I've got a case right now where the maternal aunt is trying to steal from the orphan, her 15-year-old niece, because she feels entitled to her dead brother's estate. Like it's sick, but she's also like lost her mind because her parents both recently died and now her brother has died and somehow this is her way to grab everything. And so unfortunately, he did not have a plan in place of how to take care of his 15-year-old daughter. So a different side of the family is coming into fight. You know, these are real life situations because they didn't create a plan. And they didn't, or if the plan was created, it was not well thought out. It was like, oh, I hope, I want, I wish, I want my kids to get along. If they didn't get along growing up, they're not going to get along now. When you start grieving, it is when you go back to your 7-year-old self. Who got the bigger bike? What are they fighting about? Those kind of things. So that's why it's important. Discussing the contents of these advanced directives and talking with your agents. Things that are done in secret create problems. And so if you have open conversations, it's not going to be a bad situation, right? If you are watching this and you are the caregiving child and you have two siblings, one in Florida, one in Tennessee, and they're like, everything's fine. Oh, I know, take care of them, take care of mom and dad. You're doing great. You're doing great. Nothing's in writing. In a couple years, after you've given up your entire life, they're going to say, well, I would have done it for free if I lived there. I hear that so often. What is wrong with having an open conversation saying, look, this is hard. I mean, I can tell you, I gave up caregiving after 3 months. I was incapable of doing it. I called my brothers and said, I cannot do this. And I know how hard it is. And so, but people who aren't doing it don't. They don't know. And so it's important to have this discussion with, hey, I'm going to do this. I don't want anything while mom and dad are alive, but I would like to be paid $3,000 a month for every month that I take care of them. And I want it paid in part of as part of my inheritance. I want it paid first. You can do things like that. And if you have, and you put it in writing, you can pre-create these to prevent disputes. I mean, there's a case that's been going on since the year 2000, and I'm not lying. The litigation started in 2011. They're still fighting over the house, who gets the house, because the claim is the caregiving daughter moved in, gave up her life, and she moved in with the house, and that mom promised her the house. The other two are saying, no, she didn't. And this has been going on since 2011. It is 2026. So please don't be that. That's why you want to talk about it. You also want to talk about what the institutions need, because powers of attorney are the bane of my existence. We have to get more court orders to get people to enforce certain things than I've ever believed in. But it's because banks can make their own rules. So ideally, you want to have the financial institution kind of bless it in advance. What about when we are outside of California? Because we are lawyers licensed in individual states. So you want to seek counsel from a licensed attorney in that state. I am a CELA, a certified elder law attorney. Jean had said I'm one of the only two. I'm actually one of the only four in San Diego County, but there's only two that are practicing in this area. That's the exception. But there's only 19 of us in all of California, just by way of how few there are. But every state, and so we have a connection, we have a database. You can go online, I think it's on here soon, and find a certified elder law attorney in other states. Because you're going to think about that, like, well, maybe we're going to move to Tennessee, or maybe we're going to move to Virginia. You might want to have a consult and see, I've got that right now. We did a conservatorship for somebody, and they are now moving out of state. And so we've got to transfer it over. It would have been nice if they would have had that plan in advance so we didn't have to incur the additional expenses, but we can always do it. Again, as I said, California is an island to itself. Our Medicaid is different than everywhere else. And so if you're gonna do any of this advanced planning, make sure you're never moving. And so there are a lot of those special considerations when you're relocating with a person with dementia. Okay, this is bizarre how sometimes it moves and sometimes it doesn't, everyone. Okay, so while I'm waiting for the slides to flip, I can answer a question. How do you minimize fraud when using a professional fiduciary? Before I go to legal resources, I'm going to answer that. They did a study on it, and I'm going to make up the number now, but like 98% of all fraud is done by family members. Or something like that. There was the exception for Nevada and New Mexico, and there's a movie about it, the I Care a Lot, that makes it appear that private fiduciaries and professionals are bad guys, but they're the ones that come in to save everybody. They're the ones that save for the bad kids, because good people go bad. Kids get entitled. As I just said, it's like, well, I'm the one that's doing all the work. My siblings aren't doing anything. They're the ones that end up being the bad guys in estate planning for the most part. Private fiduciaries are usually the saviors. They're the ones that come in and prevent the loss, the theft, all of that. Number one, they're licensed. And number two, it's a very small community. So we all know each other. And yes, there have been some bad apples, but when you statistically look at it, I think there's only been one fiduciary, and that I know of in San Diego County, that has gone to jail for this, because that was a long time ago when it was brand new and not much oversight. So that's my 2 cents on that. Again, I represent a lot of them, which makes me feel a lot better because I know exactly how they run their businesses. So I get to see it. But again, if you have a private fiduciary involved, there's accountings, like for me, this is what I did, just so you know, because I'm paranoid. Good people go bad. I have minor children. If I get hit by the bus, a professional fiduciary is going to manage their money till 25, 30, 35. That person has to account to a lawyer that I trust in Orange County. And if that lawyer gets hit by a bus, then somebody else. So not only do the guardians of my children have to get oversight of everything, but another third party gets oversight. So that's just because I want to have that kind of protection in place. So nothing's done in a vacuum when it comes to professionals, and that they don't want it. I have fiduciaries that don't have any accounting obligations and they still send me accountings because they are like, I want somebody to see this. And I said, I don't want that responsibility, but I do it anyway. So the legal resources. The National Academy of Elder Law Attorneys, NALA. So I'm a NALA member as well. They are not just certified elder law attorneys, which is the National Elder Law Foundation. Those are just certified. The NALA attorneys are anybody who does this type of work but did not sit for the CELA exam or maybe not pass it. And, if a California attorney didn't pass it, don't think they're not smart. The CELA exam requires you to learn all of the national law that we don't do here in California. So in addition to California, because there's a California specific exam, as well as the national. You can't hold that against people, in my opinion. But if they're not a NALA member, I would really question it because that's where we get all of our education. You also want to look at the state bar. Please make sure that they are licensed and they don't have a lot of claims against them that are actual sanctioned, because look, people make claims all the time. Disinherited beneficiaries get upset all the time. And then they're just crazy people. But be mindful of actual claims. And then the San Diego County Bar Association is always going to be a good resource. Okay, so there's a question about the difference between an elder law attorney and an estate planning attorney. It's a really easy answer. Every elder law attorney can do estate planning, but estate planners can't do elder law. So as I said at the beginning, elder law is a 12 subject matter practice area. Not all elder law attorneys practice, like I don't do Fair Housing Act claims. But one of the subject matters of that 12 is estate planning. So that's kind of why. So a standard estate planning attorney isn't going to be able to help with really implementing a really well thought out long-term care plan. We do teach estate planners on how to kind of think it out. So they do a pretty good job. But when it comes to the high end Medi-Cal and VA planning, like those asset protection trusts I talk about, they're not going to do those. I'm still trying to move the slide. Okay, Alzheimer's San Diego. As I said, I love this organization. I have been working with them since they were created because I was working with the prior entity. I adore them on a personal level. They've really helped some of my clients. I'm going to cry because there's a few people that come to mind in particular that they saved their lives. And I'm so grateful to what they've done and the access that they had. And so I think I'm going to have Jean kind of walk through some of these programs for you.
Thanks, Kim. I don't know, are you seeing me?
Yes.
Okay, sorry. There I am. I'm not going to take very long, other than to say, we've got some great staff at Alzheimer's San Diego, lots of knowledge in that whole group, and all our programs and services are free. So please contact us, and whatever it is you're looking for, the likelihood that we can help you is strong. So please call us. Our number's at the bottom here, and you'll get these slides. It's 858-492-4400, and the website is alzsd.org. I want to turn over the rest of the time to you, Kim, because there's still some questions. And of course, as always happens, people are clamoring to get a little bit more time with you. So we've got, I guess, about 7 minutes left. So I'll turn it over to you.
Okay. So I will kind of go through some of the questions I see. One of them was, if you have a trust in place, does a holographic will, can it replace it? So a holographic will is only a handwritten will that will govern anything that's not inside your trust. So if the trust is empty and there's no assignment or way to transfer all the assets into it, then it would govern. I would need more information on that. let's see. And somebody's like, who can review things and what we have in place? Again, Alzheimer's San Diego has a list of referrals, and my office also does as well for people who can review these plans to make sure you've got them in place properly. Just to make sure you've got the right people listed, what it means. I think a lot of times they weren't explained by their counsel what these documents were. I hope today's a little more helpful because when you go back and look at it, you'll be like, oh, the trustee's the manager. Okay. The power of attorney, the agent, that's going to be the manager, right? It's just like take out some of the fancy language and just put it in who they are. Um, it says if a living trust is listed as a beneficiary, should there also be a contingent? If on it's like IRAs, 401ks, life insurance, you've named the trust, that should be enough because your trust has all of the contingent beneficiaries listed there, but I would need to see it specifically, so I did not give you any legal advice. Let's see. So question is, I have a trust that was done 10 years ago with a local lawyer. Should I restart with them or find a new one? Again, I would check with the resources. If you were not happy with them, then, an attorney is a service provider. You need to feel comfortable with them. You want to be able to know that you can trust them and that what they're saying is accurate. Here's the little guide. If a attorney gets frustrated or upset with you for questioning them, run away. That applies to your doctor, your architect, your engineer, your financial planner, your realtor. Anybody who gets upset with you for wanting more information is either not smart enough to answer your question or is trying to defraud you. I'm just letting you know that there's no middle ground on that ever. I have never seen a difference. It is black and white, just so you know, because people that don't know and are confident in what they do and are not trying to defraud you will say, I don't know, let me look that up. If their ego's getting in the way, it means they're not competent. Um, okay, so I have a joint bank account with my mother. It's her money, but my name's on the account. Is that okay to qualify for Medi-Cal? So that money will be hers according to Medi-Cal as well. So it's both of yours at this point because there's an undivided 50% interest. So that money would still be counted as her money. It wouldn't be recoverable because it's going to go to you so long as you don't die first. Okay, so my 88-year-old mom's paid into long-term care through CalPERS. It's time for me to open a claim. Um, okay, insurance companies. So I make the joke with one of the first cases I had out of law school was an insurance bad faith claim because an insurance company denied an insurance policy that was really inappropriately denied. Insurance companies have a internal benefit to not pay anything, right? That is the way it works. So the best thing you can do is when you're going for your long-term care insurance, our people in general, as a human nature, we don't like to admit when we're declining. We have pretty big egos when it comes to that kind of thing. So we want to describe our best day and we want to maybe be Superman that day. So what you're going for is you need to make sure that they describe their worst day, right? The days that they need help, not the days that they don't, because we all have good and bad days. So that's how the tips and tricks for anything, for getting IHSS, for getting long-term care you need to talk about your bad day, your worst day. That's the day you need support for. So don't say, well, today I'm fine. I can go to the post, I can get to the mailbox, I can make my dinner, I can change my bed. You talk about the day the arthritis is so hard that you can't hold a cup. Like you can't hold a knife, you can't hold a spoon. Those are the days that we talk about. And that's the best advice I can give. Let's see, do you advise? Yes, so when it comes to financial institutions, I really recommend checking with them on what they want. But legally, the statutory form power of attorney is sufficient. Um, let's see. So 30-year-old Ro was created by herself. She was an attorney. How do I find it and review it with her? Oh, wait, follow up. Which question was this? So nothing gets filed. So wills and trusts don't get filed with the state. Nothing gets filed with the state. You can record your power of attorney for healthcare, your advanced healthcare directive, but most people don't do that, especially because they change all the time. So Any advice for managing a parent with mild or moderate who's at risk for mismanaging? Yes. That is a number one, call San Diego Alzheimer's, or Alzheimer's San Diego. I did that backwards for this. They have a lot of social workers that will help. I'm a big believer in, number one, remembering they need dignity and treating your parent, not parent, like remember the role, right? Parent child. This is a role reversal. If your parent is going to fight you if you reverse that role too quickly on them. So giving them the dignity and respect is number one. Number two is trying to bring in other people that will be less threatening, like I'm not your child, don't how dare you treat me this way, is usually very helpful. If they're at the stage where they need some therapeutic fibbing, I'm not opposed to that at all. And then reminding them that the more they're willing to accept help, the more independent they remain. It's only when people become really combative that that's what we're dealing with. I have a case right now where I sent the children off based on their fact pattern in an attempt to avoid a conservatorship. I think it's inevitable, unfortunately, but I armed them with some tools to go try and protect mom from herself, because it's worth it, right? We don't want to go nuclear if we don't have to, but even though she has an estate plan in place, she is a danger to herself. And unfortunately, I think we're going to have to usurp her wishes in order to protect her from herself and from the bad guys that are taking advantage of her. How does minimum income eligibility work if you're single? So there is no MIMNA if you're single. If you're a single person for Medi-Cal, it is just whatever the 138% of the federal poverty level is. So I'm going to say the 2000 range right now. If it is a skilled nursing facility, though, your income is really just irrelevant because what happens is everything above that, it just goes to your share of costs. So basically, Medi-Cal takes 100% of your income and you keep $35. In a skilled nursing. So I'm having an issue with siblings trying to get a power of attorney signed by my parents whose capacity in questioning due to diagnosis. Okay, so the best way, the only way really, if you've got warring siblings, if you've got, I call them good son, bad son, or good daughter, bad daughter. If you've got somebody who's trying to usurp a longstanding plan, unfortunately, that is kind of one of the reasons I get involved is we do have to do some sort of maybe conservatorship action preventing the execution of any later signed estate plans. Because again, right, we talked about probate code 810, you're presumed to have capacity. So if mom or dad sign a new power of attorney, it's presumed valid, even if the diagnosis, right? Because the diagnosis alone is insufficient to deem you to lack capacity. That means that we have done this regularly. We go in regularly to suspend recently signed powers of attorney, terminate those, and prevent mom or dad from signing anything new. And so we don't go full nuclear, meaning we're not trying to take away all your legal rights. We're just trying to take away your rights to usurp yourself because you're susceptible to undue influence or whatever it might be. Those are very fact specific questions. And so those are what we would need like a full consult for. How does a power of attorney get activated? It gets activated based on the terms of the document. There are two kinds. There's immediate and there's springing. Immediate means it says it in the document. This document becomes immediate upon signing. So the day mom and dad signed it, that's the day it becomes effective, or the day you sign it. When it is springing, it will say what it takes to spring. And it's usually 2 letters of incapacity. So 2 doctors have to say, the principal lacks the ability to manage their affairs. All right, and last one I see is my mother is in mid to late stage dementia and still number 1 on my dad's power of attorney. I'm second in line. To remove her, you probably just need to get 2 letters of incapacity. So look at the document and see what it says in it. It probably says it defines incapacity in some way. But if you get 2 letters of incapacity, then I would just staple it to the powers of attorney, and now you're the only actor. Okay. And yes, you can always call the office. I'm
Yeah.
around. I'm here.
Thank you so very much, Kim. This was just really fantastic. Every time I am lucky enough to be your, I don't know, your co-pilot in Zoom, I learn new things myself. And you're just a powerhouse. And we're so grateful for your presence in the community and for everything that you do, just beyond that, just for our organization and your advocacy efforts. I really mean what I'm saying. Um, you're a superstar in my book. So thank you. It was really terrific. I just want to say to everybody, please let's all say thank you to Kim. She gives her time to us here today, and by doing that, she's giving her time to you folks. So it's really something. Call us with questions. Any of those resources that Kim talked about, we can give you the information. And most certainly, you can also follow up with her. See, one of the best presentations ever. There you go. Yes,
Thank
you can call her for a full consult on this power of attorney issue. So, again, our deepest thanks, Kim, and we will close the webinar. Everybody will get a copy of the slides tomorrow, and we'll have the recording posted on our website in about a week or 10 days. So thank you very, very much, everybody. And Kim, take care. We'll see you again.
thank you.